You're in the middle of a routine traffic stop. Maybe your taillight flickered, maybe you rolled through a stop sign, or maybe you just fit a description. The officer walks up, asks for your license and registration, and then, just as you think it's going to be a warning, he stops. He tilts his head slightly, he inhales through his nose, and then he says the four words that change everything. I smell raw marijuana. Your heart rate spikes. Your palms get damp because you know, or at least you think you know, what comes next. A search of your car, your belongings tossed onto the asphalt, possibly a dog, definitely handcuffs if they find anything. But here's the question that most people never think to ask in that moment, and it might be the most important question of their entire encounter with law enforcement. So I want you to pause and really consider this before we go any further. If a police officer tells you he smells weed, what is the single most powerful response you can give? One word, one sentence, that could change the entire legal trajectory of that stop. Go ahead. Think about it. And while you do, type your guess into the comments. Because what you're about to learn is something that most criminal defense lawyers wish every driver knew, and something that police academy training rarely wants you to understand. Let's rewind. The year is 1977. A man named Fernando Delaware is pulled over in Los Angeles County. An officer claims he smells marijuana emanating from Delaware's car. No dog, no visible contraband, just a nose. The officer searches the trunk, finds a small amount of cannabis, and Delaware is arrested. His lawyer challenges the search, arguing that a smell alone, without any corroborating evidence, should not justify rummaging through someone's private property. The case works its way up, and in a decision that surprises almost no one who studies Fourth Amendment law, the court rules against Delaware. The logic? If a trained officer detects the odor of an illegal substance, that odor gives him probable cause to search the vehicle. That was 1977, and for nearly 50 years, that rule has been one of the most powerful tools in American policing. But here's where the story gets complicated. Fast forward to 2026. Today, 38 states have legalized medical marijuana. 24 states have legalized recreational use. And here's the staggering number. Over half the U.S. population now lives in a jurisdiction where adult cannabis possession is not a crime. So ask yourself this. If an officer says he smells weed in a state where weed is legal, does that smell still give him probable cause? The answer is not as simple as you think, and that ambiguity is exactly where your rights live. Let me give you a real example. In Massachusetts, after recreational marijuana became legal, the state's highest court ruled that the smell of burnt marijuana alone, without additional evidence of impairment or criminal activity, does not justify a warrantless search of a vehicle. The court said, and I'm paraphrasing here, that since possessing small amounts of marijuana is no longer a crime, the odor alone doesn't signal a crime. It's like the smell of tobacco. You can't search a car just because you smell cigarettes. That was a landmark decision, and other states have followed similar reasoning. But here's the catch, and this is where most people get tripped up. Not every state agrees. In Texas, where marijuana remains largely illegal, the smell still gives officers broad authority. In Idaho, same thing. In Nebraska, same thing. So the first thing you need to understand is geography. Your rights literally change when you cross a state line. But let's get to the core of this video. The title promised you a specific phrase to say back when a cop claims to smell weed, and I'm going to give it to you. But first, I need you to understand why this phrase works and why saying anything else, or worse, saying nothing, can be a catastrophic mistake. The phrase is this: I do not consent to any search. That's it. 4 words. But here's what makes them powerful. When an officer says, I smell marijuana, he is announcing his belief that he has probable cause. Probable cause is a legal standard that allows him to search without your permission. But here's the critical distinction. Probable cause is not self-executing. An officer can believe he has probable cause. He can act on that belief. But if a court later decides that his belief was wrong, any evidence he finds can be thrown out. And that's where your non-consent becomes a shield. Because if you stay silent, or if you nod, or if you step aside, prosecutors can argue that you voluntarily consented to the search. But if you clearly, audibly, and unambiguously say, I do not consent, you have drawn a legal line in the sand. You have preserved your right to challenge the search later. You have forced the officer to rely entirely on his claimed probable cause, not on your cooperation. And here's the psychological layer that most civilians never consider. Police officers are trained to look for signs of consent. When you roll down your window all the way, that's consent. When you open your door without being asked, that's consent. When you say, "Go ahead, I have nothing to hide," that's the golden ticket for the prosecution. But when you say, "I do not consent," you shift the dynamic. You signal that you know your rights. And in many cases, not all, but many, an officer who hears that phrase will pause. He might call for a canine unit. He might write you a ticket and send you on your way. Or he might search anyway. But if he searches anyway, your lawyer will have something powerful to work with, a clear record that you objected. Now, let me anticipate the question forming in your mind. Does saying, "I do not consent," ever make the situation worse? Could it anger the officer? Could it escalate a routine stop into something more dangerous? This is a fair question, and any honest legal commentator would address it. The answer is yes, there is a risk. Some officers interpret a refusal to consent as defiance. Some become more aggressive. Some will find a reason to detain you longer. So you have to weigh your safety against your legal interests. But here's what the data shows. In the vast majority of traffic stops that do not involve violence or outstanding warrants, a calm, polite, non-confrontational statement of non-consent is not an escalation. It is simply an assertion of a constitutional right, and officers hear it more often than you think. The key is your tone. You don't shout it. You don't say it with attitude. You say it the same way you would say, "I'd like to speak to my attorney." Calm, firm, respectful. But we're not done. Because the smell of marijuana has become even more legally complicated in the last few years. Consider the rise of hemp. Under the 2018 Farm Bill, hemp, defined as cannabis containing less than 0.3% THC, was legalized at the federal level. That means it is now entirely legal to possess, transport, and consume hemp products. And here's the kicker. Hemp smells exactly like marijuana. Exactly. The same terpenes, the same skunky aroma, the same pungent profile. So when an officer says, "I smell weed," ask yourself, does he smell illegal marijuana? Or does he smell perfectly legal hemp? And here's the really interesting part. In several federal court cases, judges have ruled that the odor of raw cannabis alone, without field testing or other indicators, is no longer sufficient to establish probable cause, because that odor could just as easily come from legal hemp. One case from Florida in 2021, State v. Smith, made exactly that point. The court said, and I quote, "The legalization of hemp has rendered the smell of cannabis alone unreliable as a basis for probable cause." Let that sink in. A federal judge said that the smell of weed is no longer enough. That's a seismic shift from the 1977 case we talked about earlier. But here's the reality on the street. Most officers have not gotten that memo. Most district attorneys will still argue that the smell is enough. And most judges, especially in conservative jurisdictions, will still side with the officer. So we have a gap between what some courts are saying and what police are doing. And that gap is where innocent people get arrested, cars get impounded, and lives get disrupted. So let me ask you something. Have you ever been in a situation where an officer claimed to smell something, alcohol, marijuana, something else, and used that as a reason to search you or your car? What happened? How did you respond? I'm genuinely curious, and so are the other viewers watching this. Drop your story in the comments. You might help someone else avoid the same mistake. Now, let's talk about the dog. Because when an officer says, "I smell weed," the next thing you often hear is, "I'm going to have my canine unit conduct an exterior sniff of your vehicle." And this is where another layer of rights comes into play. The U.S. Supreme Court ruled in Rodriguez v. United States that a police officer cannot extend a traffic stop beyond the time reasonably required to handle the traffic violation just to wait for a drug dog. In plain English, if you get pulled over for a broken taillight, the officer can ticket you for the taillight. He can run your license. He can ask basic questions. But once he finishes those tasks, the stop is over. He cannot hold you for an extra 10 or 20 minutes while waiting for a dog to arrive unless he has reasonable suspicion of some other crime. And what counts as reasonable suspicion? The smell of marijuana, in some states, does count. But remember the hemp problem. Remember the legalization problem. A good lawyer can argue that the smell, by itself, is not enough to justify prolonging the stop. And if the officer prolongs the stop without legal justification, everything the dog finds can be suppressed. I want to give you a real-world example. In 2015, a driver named Dennis Rodriguez was pulled over in Nebraska for driving on a highway shoulder. The officer completed the traffic stop, wrote a warning ticket, and then asked for permission to walk his dog around the car. Rodriguez said no. The officer did it anyway. The dog alerted, and officers found methamphetamine. The Supreme Court ruled 6-3 that the dog sniff violated Rodriguez's Fourth Amendment rights because the officer extended the stop without reasonable suspicion. That case changed traffic stop procedures across the country, and yet, most drivers have never heard of it. So here's your practical takeaway. If an officer says he smells weed and then tells you to wait for a dog, you can say, politely, "Officer, am I free to go?" If not, what is the legal basis for detaining me beyond the traffic stop? That question forces the officer to articulate his reasonable suspicion. And if he can't, or if he stumbles, you have just created a record that will help your lawyer later. But let's be brutally honest. None of these legal strategies work if you are actually carrying illegal drugs. If you have a pound of unlicensed cannabis in your trunk, saying, "I do not consent," is not going to save you. The officer will search, he will find the drugs, and you will be arrested. The purpose of this video is not to help people hide evidence. The purpose is to protect innocent people who are caught in a legal system where the smell of a legal substance, hemp, or legally purchased medical marijuana can be used to justify an invasive search. And also to protect people who know their rights and want to exercise them without being steamrolled by the authority of a badge. I want to take you back to 1968, a case called Terry v. Ohio. You've probably heard of stop and frisk. That case gave police the authority to pat down a person's outer clothing if they have reasonable suspicion that the person is armed and dangerous. But here's what most people don't know. The Terry decision was supposed to be limited. The Supreme Court said that a frisk is not a full search. It is only a protective pat-down for weapons. And yet, over the decades, that exception has been stretched, twisted, and expanded. Today, many officers treat a Terry frisk as permission to pull things out of pockets, open containers, and essentially conduct a full search. That is not what the Constitution says. And if an officer says, "I smell weed," and then pats you down, you have the right to say, "You do not have my consent to reach into my pockets." Again, you say it calmly, but you say it. Now let's address a question that I see constantly in online forums and comment sections. What if you're a passenger? What if you're not the driver? The same rules apply. You have the same Fourth Amendment rights. An officer cannot search your purse, your backpack, or your pockets just because the driver did something suspicious. The officer needs probable cause directed specifically at you or your consent. So if an officer says, "I smell weed in the car, I'm going to search everyone's bags," you can say, "I do not consent to a search of my personal property." And if the officer searches anyway, any evidence found in your bag may be inadmissible against you. Let me give you a powerful statistic. According to the American Civil Liberties Union, despite similar rates of marijuana use across racial groups, Black Americans are nearly 4 times more likely to be arrested for marijuana possession than white Americans. Traffic stops are a major driver of that disparity. The smell of marijuana is subjective. It cannot be measured. It cannot be photographed. It cannot be verified. It is entirely dependent on the officer's word. And when an officer says, "I smell weed," especially in a jurisdiction where that smell gives him probable cause, he has effectively given himself a blank check to search anyone he wants for any reason as long as he is willing to say those 4 words. That is not speculation. That is the conclusion of multiple federal judicial opinions, including a scathing concurrence by Judge Alex Kaczynski in the Ninth Circuit, who wrote that the smell of marijuana has become a pretext for searches that would otherwise be unconstitutional. So what do? You educate yourself. You practice the phrase. You say, "I do not consent to any search." You do not argue. You do not resist physically. You do not run. You simply make your objection clear, and then you let the officer make his decision. If he searches and finds nothing, you go on your way. If he searches and finds something, even something legal that he mistakes for illegal, you have preserved your right to fight it in court. And here is the final layer. The most important thing you can do after any traffic stop is to remember as many details as possible. What was the officer's name and badge number? What time did the stop begin? What time did it end? How long did you wait for the dog? What exactly did the officer say when you asked if you were free to go? These details are gold to a defense attorney. Write them down as soon as you are safe. Or better yet, if your state allows one-party consent recording, turn on your phone's voice recorder before the officer even reaches your window. You don't have to announce it, just let it record. In many cases, an officer's own words on a recording will contradict his police report, and when that happens, cases get dismissed. Let me leave you with this. The smell of marijuana is not evidence. It is an assertion. It is one person's sensory claim. And in a country where millions of people legally use cannabis every day, where hemp is legal nationwide, and where the Constitution still protects you from unreasonable searches, you have the right to question that assertion. Not by arguing on the sidewalk, not by resisting arrest, but by calmly, clearly, and respectfully saying the words that preserve your right to fight another day. I do not consent. So here is my final question for you, and I really want you to answer in the comments. Before watching this video, what did you think you were supposed to do when a cop said, "I smell weed"? Did you think you had to open your car door? Did you think you had to step out and let them search? And now that you know the power of non-consent, how will you handle that situation differently? Your answer might be the thing that helps another viewer avoid a life-altering mistake. Thank you for watching. Thank you for caring about your rights. And remember, the law only protects you if you know how to use it. Stay safe out there.